Chrissy, here's a text from Pat, and he's got a trust that's several years old. He wants to make some changes. How do you do that? How do I need an executor? When you have a trust and you want to make changes to it, you do it through a trust amendment. So you don't start from scratch. Usually you just amend the thing. At some point in time, you might have so many amendments after you've amended it 4, 5, 6, 7 times. It's time to do what's called a restatement of trust, where you do throughout all the old and you start from scratch. When you start from scratch with your restated trust, you continue to use the same name and date of the trust. So you're not changing, you don't have to change any of your assets that are already titled in the name of the trust. You're just doing a restatement, making things nice and neat. Chrissy, speaking of making changes to your will or trust, every once in a while I have a client come to see me where they need to make changes and they pull out their will or their trust. And over the last few weeks or months, they have pulled out a pen and they started writing over making notes on all their original documents. And folks, please don't do that. If making notes on the document to clarify what you want to have done, you got the right idea, but first copy them and make your notes and changes on the copies of your documents, not on the originals.
Correct. What does it mean if somebody does that? If they write directly on the original will or trust and they make those changes, just for the listeners to be aware out there, it means those changes would not be legal.
Nope. And it'd be a big mess too.
So the original trust or will is what will be governed by Florida law. That's what will be taken into effect if the person passes away, not the handwritten notes on top. Florida does not recognize that. My understanding is that most states don't. So therefore, this is a lot of times, if let's say grandparents and they're giving some cash to grandkids and they change it. Oh, instead of giving them $3,000, I'm going to give them $5,000 each, and they cross it out and they put the new number. The new number will not be legal and will not be able to be put into place. It'll be the old number or whatever information is on the original will or trust.
That makes me think about how many times clients have come to see us and go, "Hey, Tom, I've got a trust. I want to make changes to it." "Oh, great. Come on, see me. Bring your trust with you." And they come in, they bring a notebook, and I start looking at their documents. They're not even the originals in their notebooks. They're got copies stamped all over them. Well, where are the originals of these documents? "I don't know. I thought these were the originals." Or sometimes you find stamped on there the originals held by the attorney that drafted these documents. "Well, where's that attorney?" "I don't know. He's retired. I don't know. He passed away. I can't find him anymore." So first of all, make sure that you've got the originals of your documents. We always sign things in blue ink here at the Olsen Law Group. That way we clearly can tell what's an original and what's not an original. Sometimes I look at copies of documents and I'm thinking, is this an original or is this a copy? I don't know. It's got clearly it's got black signatures on it. But copies machines are so good these days, sometimes it's hard to tell what's what.
Correct. You must have the original, and you should not write over the original.
Yep.